Supreme Court has ordered a New York State court to reconsider its decision on a case regarding mandatory coverage for abortions in New York State insurance. The law allows for very few religious exemptions, which prompted the suit from a variety of religious orders and organizations, including an Anglican order called the Sisterhood of Saint Mary. And joining us now is Eric Baxter, Vice President and Senior Counsel at Becket. Eric, great to see you. So good to be with you. For those who are not familiar, tell us a little bit more about this case and why it's so important, not just for the Sisterhood of Saint Mary, but also for other religious groups.
Well, your viewers have probably heard of the contraception mandate that's been in the court for almost a decade. The state of New York tried to one-up the federal government on that and impose an abortion mandate requiring all employers to cover surgical abortions in their health care plans. And so our clients, religious churches, Catholic, Anglican, Baptist, Lutheran, a wide group of religious organizations, of course, have religious objections to participating in abortion. And so we are participating in the suit against the state of New York, asking for an exemption for their religious beliefs.
And Eric, why were they denied originally a religious exemption? What disqualified them under New York state law?
Yeah, the exemption that was put into the law is ridiculously narrow. Jesus himself would not qualify for it. It basically protects churches that are very inward looking, but if you walk outside the walls of your house of worship, you're not protected. If you serve people outside of your church community, you're not protected. That's a completely unfair and ridiculously narrow exemption. And so our clients, they want to serve people of all faiths in their community. They want to employ the best people to perform those services, whether they belong to their faith or not. And so because of that, they were denied an objection. And we've argued that that's a violation of their religious beliefs and their rights under the Free Exercise Clause.
And what happens to the groups that are petitioning against the mandate in New York? What happens to them if they don't comply? What type of penalties could they face?
Well, they're forced to drop their insurance for all of their employees. And part of their religious belief is also to take care of their employees and make sure that they are well provided for, that they have the health insurance that they need for their families. And all of those employees would lose their health insurance if the churches refuse to participate in abortion. And that's, I think, one reason why the Supreme Court remanded this case and told the New York courts they have to reconsider this decision.
And what comes next in the case? What can we expect?
Well, we will expect the New York Intermediate Court of Appeals to hear this decision again. The Supreme Court, I think, will be watching this very closely. 3 of the justices, Justice Thomas, Alito, and Gorsuch, indicated that they would have taken the case themselves and decided it. They needed a 4th justice to be able to do that, but they sent a clear signal that they will be watching the state courts, and so the state courts will have a chance to reconsider the case. And then I think there's an opportunity, if they get it wrong again, we'll be back at the Supreme Court.
And Eric, before I let you go, quickly, what other cases are you following? What do you have your eye on right now?
Yeah, there are a number of other interesting cases on this similar issue, cases hospitals required to perform transition surgeries against their religious beliefs. And we think the court will be watching this issue generally, whether religious organizations are allowed to serve the public without giving up their religious beliefs. But we're very confident in the end that the court will rule in favor of the religious organizations. In fact, in remanding this case, the abortion mandate case to New York, the Supreme Court relied on its earlier ruling in Fulton versus Philadelphia, one of Becket's cases where we defended religious adoption providers. And the court there made clear that you don't give up your religious beliefs just because you go into the public square to serve the public. And so we believe that in the end, the court will respect the rights of religious organizations to serve in accordance with their faith and without having to participate in activity that violates their deepest held religious beliefs.
Eric, thank you so much for your time and for your analysis today. Eric Baxter, Vice President and Senior Counsel at Becket. Thank you again.
Thank you.